The darkness continues.
Peace, spoke, and welcome back to another edition of the Proper Thought series right here on the old T.P.O.T YouTube page. I'm your host, X, of course, but you knew that already. That's why your black asses are here. Well, I'm back with another. And yes, the darkness does continue. Today I thought I would bring y'all something a little different from the other side of the country. We are in Grays Harbor Superior Court. And Grays Harbor is in Montesano, Washington, all the way on the West Coast. And we're in the courtroom today of the Honorable Judge XoDus. Hopefully I'm saying that right. And what I want to show y'all today is how white justice is doled out amongst white people. You're going to see a case where a white man is being accused of some pretty serious crimes. He has somewhat of a history, but the judge does show him a bit of humanity. And I want you good folk to decide if this same type of humanity would be doled out in the justice system if this was a brother accused of the same thing, whether it be with this judge or another one. But you'll get to see it for yourself. Of course, I'll be stopping it periodically, and you can come to your own conclusions. So, without further delay, let's get at it. And as always, fair use, Negroes. Fair use. Well, all right. As stated, we are in the courtroom of the Honorable Judge XoDus. And like I said, we are in Montesano, Washington. And y'all are about to see, you're about to see a different judge. This is the first time that I put this judge on. This isn't a judge from the East Coast. Like I said, it's in Montesano, Washington, which is all the way out on the northwest coast of the United States. And I want y'all to take into account all the things that I've shown you before. And I want you to ask yourself the question: is there a difference between black and white justice? So, without further delay, let's get at it. And as always, fair use, Negroes. Fair use. Take it away, Judge XoDus.
All right, thank you. So, Mr. Foster, you've been booked on probable cause for vehicular assault and felony hit and run. At this time, no formal charge has been filed against you. The state does have 72 hours from the time of your booking, excluding weekends and holidays, to make that charging decision. I have reviewed the declaration of the prosecutor. I do find probable cause. And so at this time, you do have the right to remain silent. Anything you say may be used against you at a future hearing. You also have the right to be represented by an attorney. And if you cannot afford an attorney, one will be appointed to you at no expense. Do you understand those rights?
Yes, Judge.
So, Mr. Foster, you were screened by the Department of Public Defense and found to qualify for for an attorney at public expense. Are you asking to have an attorney appointed to you?
That'd be great. I would appreciate that. My family was talking about getting one if the attorney doesn't work out.
So you if your family wishes to hire an attorney for you at a later time, with some exceptions, that usually is not an issue. If there are some circumstances where that's not allowed if it's too late in the process, but an attorney can advise you on that. But for now, I'm going to appoint Preston White to represent you. Mr. White is going to be notified of the appointment.
Okay, so let me break in here. He's been charged with vehicular assault, felony hit and run, right? Now he's got some felonies. So, with these felony charges, from watching, Judge King, it all depends on, the mitigating factors of, what you're accused of, what the allegations are, what the district attorney has against you, et cetera, et cetera. That's usually the determining factor whether or not, you get bond, how high your bond is going to be, whether or not you get a personal bond. So all that stuff plays into it. Now we're going to go a little further, because she's basically giving him the generic, you have the right to remain silent. You have a right to an attorney. If you can't afford one will be provided to you, at no cost, et cetera, et cetera. We've all heard it all before. So we continue. Fair use, Negroes. Fair use.
And you'll be given his contact information, and you should reach out to him at your earliest opportunity.
I will.
When is the state going to be prepared to address charging?
Your Honor, I believe we set the co-defendant case on for Thursday. I would ask for I believe it was Thursday, whatever that same day, I'll be fine. I'm confident I'll receive the full reports either later today or tomorrow morning.
So the white man has a co-defendant on this case as well, right? And keep that in mind. But we continue. Fair use, Negroes. Fair use.
But all I've got for now is that probable cause statement.
I'm sorry. Can you do me a favor? Can you speak up and slow down? I'm at the end of a cold and my ears are not
I apologize, Your Honor. I would be ready to go either tomorrow or Thursday. I think the other companion, the co-defendant case, I can't recall if it was set Thursday. I think it was, but I'm not 100% on that.
It's set for tomorrow at 8:30.
Okay, I would then ask that we set this one on Thursday because I won't be ready for that tomorrow morning.
All right. So, Mr. Foster, I'm going to set the next hearing in your case for Thursday. That's January 12th at 3 p.m.
January 12th at 3 p.m. And that's at the Montesano Superior Court, right?
Yes. And you should make sure that you talk to Mr. White prior to that hearing.
Yeah, I will.
So Thursday at 3 p.m. What is the state's position on bail or release conditions?
Your Honor, I can tell the court that the co-defendant who had no criminal history was released on his own recognizance with...
Okay. His co-defendant is out. Yeah, he's out. Now, I don't know what the co-defendant's charges were, but he is out. But we continue.
Scram bracelet and an ignition interlock device, as well as standard conditions. Mr. Foster is slightly differently situated. He has some prior history, not much, most of it old, but there were some old warrants that were issued, and there's currently an active warrant for a very old F3. I'm assuming probably just about money, but I don't know.
Now, this dude has warrants, all right? The dude you see standing in front of you with the orange shirt on, he has warrants, right? That's probably what kept him inside while his co-defendant got out, and you heard them talk about a scram bracelet. A scram bracelet is something that they put on them that usually happens when there's some type of DUI type of thing, where the scram bracelet will indicate whether or not, you've been drinking or getting high, whatever the case may be. The scram bracelet will indicate that. So the other person might have been driving. He might have been driving, all right? Because the district attorney said his co-defendant had a scram bracelet. But we continue. Fair use, Negroes. Fair use.
No.
Also,
shut your ass up. You see that finger, right? She's like, shut your ass up, white boy. You hear the district attorney talking. Look at her. She got that one finger up, like one of them old school moms, and threatening to hit you across the hand with a ruler. You see that one finger up, like, shut your ass up. But we continue. Fair use, Negroes. Fair use.
Also different is that I have no information, unlike the co-defendant who it was well established that he was under the influence. I don't have any information about that with respect to Mr. Foster. So I can't ask for those conditions in this case because I don't think it would be warranted. I do think bail is warranted, even though I'm letting the court know that co-defendant was PR'd yesterday. Mr. Foster does have additional criminal history that the co-defendant didn't have. Moreover, the report indicates that at least it looks to me like he was trying to get his story straight with his son before he went to law enforcement, which causes concern for me.
So maybe it mentioned his son. I guess his son was the one driving, because he said it did indicate that he was under the influence, and he's got the scram bracelet. And the district attorney says that it seemed like they was trying to get their story straight. But whoever this other co-defendant was, he was able to get out. This guy did not, obviously, because he's sitting in there with an orange jumper on. He's still in jail. But we continue. Fair use, Negroes. Fair use.
All right. So for purposes of today's hearing, Mr. Foster, as Mr. White is not present, Attorney Pack is present to represent you at this hearing. Counsel, do you wish to be heard?
Yes, Your Honor. I'm asking for personal recognizance. I'm looking at the charges that Mr. Peterson is mentioning, and he does have a history, but none of them are violent. And so based on that, I think a personal recognizance would be fair and equitable. And he does show in his application for pretrial release that he does have a stable address, and it looks like he has family members that live with him there as well. And so I don't see that he's any sort of community safety risk at this time. And so I'd be curious what the bail amount would be, but that nothing further from preliminary counsel.
Now, this public defender here, right? He didn't really get into specifics. Like oftentimes you hear public defenders, they get up here and, especially in the courts, further east, they get up here and they actually run quite a bit of gobbledygook like this.
Ms. Gant.
Thank you, Your Honor. Miss Kiona Lanier is 30 years old. She has been in the Atlanta, Georgia area for about 7 years. She is the proud mother of 3 sons, the minor children who are the subject of this complaint. She also has a 2-year-old son and 2 daughters, ages 12 and 9 months. She completed high school. She also completed a trade. She was working as a medical technician. At this time, she is unemployed, but she is searching for employment. Your Honor, she strongly denies the allegations. She states that when she went to pick her children up on Friday, she found that the children were alone. She states that she called the police. She states that as a result of that phone call, DFACS became involved. Her son had been telling her, the 6-year-old had been telling her that the father, Mr. Will Dawson, had been leaving the children home. Her son was crying, and she had some real concerns about the safety of her children. She states that on the day that she was scheduled to return the children, she had called out to the guardian ad litem to just get some guidance in terms of what she should do, and she did not hear from them. She did not want to return the children to the care of the father, considering her concerns that he had been leaving them alone. And of course, in light of this new open case, she states that she was able to speak to the guardian ad litem on Monday, who gave her some guidance, and at that time the police pulled up. So we definitely deny any allegations. I believe that she was justified in acting to ensure that her children are safe. We did not hear about any prior offenses in her background. She certainly is presumed innocent. We did not hear about any significant history. Therefore, I am requesting a signature bond on Ms. Lanier's behalf, as she does not have the means to pay anything toward bond, Your Honor. Thank you.
As you heard, just a bunch of gobbledygook that doesn't mean anything. This particular public defender here, I mean, he just got straight to the facts. Hey, he should get a personal recognizance bond. He has a history. None of it's violent. I think, a personal recognizance bond is fair and equitable. He didn't talk about the case at all. He just lobbied for the bond. And I think that's better than the crap you just heard a minute ago. But we continue. Fair use, Negroes. Fair use.
Mr. Foster, were you aware that you have a warrant out of Cosmopolis Municipal Court?
Of course he knows he has a warrant. I think when people have warrants, they know they have them. Because whatever got them the warrant, they are well aware of it. Because when do you get a warrant? When you don't show up to court when you're supposed to. Which means you knew about the court date because you probably got arrested on something else. So I answer again, yes, he knew he had a warrant. Or at the very least, he knew that a warrant was possible. But we continue. Fair use, Negroes. Fair use.
I tried turning myself into that multiple times. It's a old warrant. They told me not to worry about it, just to do it when.
Wait a minute. He turned himself in for the warrant, and they told him, don't worry about it. That doesn't even make any sense. You got a warrant and you turn yourself in and they say, you know what? Don't worry about it. Take care of it when you feel like it, buddy. But maybe they did say that. I mean, think about it. Because I did ask the question, is there a difference between black and white justice? Maybe when it comes to white justice, it's different. With black justice, you got a warrant, you turn yourself in, you get locked up, you go to court. But with white justice, if you have a warrant and turn yourself in, they say, don't worry about it. Take care of it, I don't know, 2 weeks from now. But we continue. Fair use, Negroes. Fair use.
It's way back before my daughter was born. So this was a long time ago. I walked out of the Hong Kong. I had drank too much, and I walked home and I forgot to pay my bill. And they called the cops, and everyone in that town. I live right across the street from the police station, so all the cops know me.
Okay, I don't want that much information.
Okay.
Shut your ass up, white man. Well, let me stop it here, right? Because you see the judge, she's, looking his stuff over, checking it. And what do you good folk think she's gonna do? What do you good folks think she's gonna do? He's got some felony beef. He's got a warrant or two out there. Obviously active because she has it in front of her. It's because she kindly reminded him that he has it or has them. So what do you think the judge is going to do? Even though he said, he turned himself in, and they told him, don't worry about it. It's just a warrant. Just go ahead. We'll take care of it later. I've never heard that before. When you have a warrant for your arrest, you go to turn yourself in. And the court and the cops, they say, don't worry about it. We'll worry about it later. See you later. Going home. Never heard that before. But we continue. Fair use, Negroes. Fair use.
Well, Mr. Foster, this is a close call for me because the allegations here are more than serious. And that being said, I have to weigh the factors that the law gives me, which are, do I believe that you will appear? And do I believe that you pose a danger to the community?
Now, I don't know about the danger to community, but you had to remind him of a warrant that I'm pretty sure, well, he knew about it because he claims he tried to turn himself in on it. So he has warrants. So does that speak to his ability to return to court or no? I don't know. But we continue. Fair use, Negroes. Fair use.
And if you do pose a danger to the community, can that be mitigated by other conditions on your release? And when I tell you that it's a close call, I want you to understand that there's no room for mistakes by you. You are going to follow the conditions that the court sets, or you're going to stay in the jail pending the outcome of your case. So I understand the state's concern but the criminal history here is really minimal. His last conviction is 20 years old.
Now, not for nothing, that plays well for him because, you know, a lot of times with these other judges that I show y'all, if you got old history, anything that's older than like 10, 15 years, they don't even, it's like you don't even have it for the most part. All right. So in this vein here, this is similar to what I've shown you good folk before. Because if your history is old, the judges don't really care. I mean, you know, 10, 15, 20 years, it's like it never happened. But we continue. Fair use, Negroes. Fair use.
They're 10 years old. There's an identity theft from 2012. But I do note here.
Okay, 10 years old. Same thing.
That he was not immediately arrested. He indicated to the police department he would come in and make a statement. He did that. He has 49 years at his current residence, so that there are considerable ties to the community. He's been employed for over 2 years at the same employer. He has a number of family members that live with him.
Now, you hear what she's saying, right? This is usually what you hear the public defenders say in other courts, right? Well, you know, Your Honor, you know, he's been living here for 49 years. You know, he's been employed at this job for X amount of time. You know, his mom is here, his sister's here, his dog is here, his hamster is here, his pet lizard is here. You know, you hear all of that. But it's not the public defender, because like I said, the public defender got right to it. Hey, Judge, I think he deserves a personal recognizance bond. So it's the judge who's actually going over his ties to the community and his worthiness of bond. Now, this is the first time I've seen this, because like I said, usually it's the public defender who's running down this laundry list of reasons for him to be out or to have a reasonable bond. But we continue. Fair use, Negroes. Fair use.
So Mr. Foster, I'm going to give you a chance. I'm going to release you on your personal recognizance, meaning
he is getting a personal recognizance bond on these felonies now. That's what he's getting. because the judge has convinced herself that he's worthy of it. She didn't have to be convinced by the public defender. She didn't have to be convinced. Y'all heard it yourself. She read it and convinced herself. And she's releasing this guy on his own recognizance. Meaning this isn't even a signature bond. He's literally just walking out the door without having to provide anything. He's just walking out. But we continue. Fair use, Negroes. Fair use.
You do not have to post bail, but you are not, I don't want you to drive during the period of your release. And you had indicated on your application for pretrial release that you could comply with that. Is that correct?
Yeah, I don't want to even get in the car, so I'm good with that.
All right, so you're not to drive pending the outcome of your case. You are not to have any further law violations. You need to clean up that warrant in Cosmopolis Municipal Court. I know that they only have court once or twice a month, so it may not be immediate, but you need to be getting that scheduled to take care of that.
Well, wait a minute. He has a warrant somewhere and she's still letting him out. Now, I don't know what's behind that. Maybe she doesn't have jurisdiction to hold him because of where the warrant is. But he does have an active warrant and he's still being allowed to get out. Did you hear what I said, folks? She's reminding him of the active warrant. In fact, suggesting that he go and get it straight. Go take care of it, sir. As she lets him out. I don't think I've seen anyone released who has active warrants anywhere. But I say again, is black justice different from white justice? Or could it be geographics? Maybe this is just how they do things over there in Washington State. I don't know. But it seems rather odd that he's walking out of here. No bond, no signature bond. Personal recognizance. And even the judge herself said the allegations are really serious. Maybe because of his history being so far in the past, that may have weighed heavy on it. But I am still somewhat surprised with how this is being handled after seeing so many different cases. But we continue. Fair use, Negroes. Fair use.
You're to have contact with Mr. White at least once a week or as often as he needs so that he can do his job. You're to reside at the address that you've given the court, and you're not allowed to change that address without getting prior permission from the court. Your travel is limited to Western Washington unless you have court permission. You're not to have under your control or consume any controlled substances without a prescription. Anything further, Mr. Peterson?
No, Your Honor.
All right, Mr. Foster, do you have any questions about those conditions?
Yeah, no, it's great. I won't let you down. I'll do everything right. I got it all. It's sunk in, so I'll make sure I call Mr. White first thing tomorrow.
If you have any,
and I will call him once a week.
if you have any questions about what's going on, get a hold of Mr. White. And the most important thing is that you're back in front of this court on time, 3 o'clock on Thursday.
Okay.
All right, thank you.
All right, thank you, Judge.
Now, what did you good folk think of that? Like I said, this is the first time that I've shown this particular judge here. Obviously, I think she was pretty fair with the white man. All right. Especially being that, she says that he's got this serious felony. All right. She even admitted it herself. She said he had a criminal history, but it was, 10 years back. Right. But what really stuck out to me is the fact that she was going down the list of things that made him worthy to get out. He's been living there 49 years. He has a job, he's got family members, he's got ties to the community, etc., etc. I've never heard a judge do that. And y'all know I bring y'all a lot of this stuff. So you know what that means? I watch a whole hell of a lot more of it than I bring to y'all. And I have never seen this before, folks. And I mean never. Now I have to ask myself, is this because this man was white and the judge is white? Or is this just a really, really fair judge? Now, I don't have any more of this judge cases to compare it to. But let me ask this. What if this was another judge? What if this was one of the judges I brought you before? Would they have just let him walk out of there without so much as a signature? Just the door flies open and you walk out? Or better yet, what if the defendant, the accused, was black and a black judge? Would they have shown the humanity to the accused that this woman showed, that Judge XoDus showed to this man? Now, we already know they wouldn't have read this list of things that, made him worthy of bond. We know they wouldn't have done that. I haven't brought you one judge that has done that, where they basically make the case for you getting out. That's something I've never seen from any judge. That's what made this stick out more so than anything else. And that's why I brought it to you good folk today, because I think that was very important. When the judge is looking for a reason to let you out, does that only happen with white judges? Does it only happen when the accused is white in front of that white judge? Does Your Honor bend over backwards to find reasons to let you out of the hoot scow? Because that argument can be made here, right? Now, granted, you heard the district attorney say that his co-defendant got out on a PR too, but the co-defendant didn't have this man's criminal history. So he was probably more deserving of it. That's why he was out and this guy was in. But what changed? What changed and made it so he's now out? What brought the change of heart? Because obviously he's in jail, so they felt it was necessary for him to be there, more so than the other person who got out. What changed? The allegations were not amended. He's still charged with the same thing. You heard the judge say his charges were serious. You also heard the judge say he had an active warrant. But with all of that, she still decided to release him on his own recognizance and told him, hey, you better arrange to get that warrant taken care of. So obviously that warrant is not going to hold him there. Maybe because it's in a different jurisdiction, but even with that, I mean, usually when you have a warrant, man, I mean, they're still going to hold you to see if these people are going to come and pick you up on this warrant. But I guess they don't do it that way there. I mean, I don't know. But not for nothing, the judge made the case of why he should be let free. It's almost as if the judge was playing public defender in a sense, because that's what we've heard public defenders say, right? What she said, usually that's your public defender saying that, not the judge. And usually when your public defender says that, it's pretty much in one ear and out the other any damn way, because I believe that the judge has made up their mind by the time the public defender starts talking. She's already made up her mind whether or not they're going to let you out or not. Your public defender speaking is just a formality. No matter what the public defender says, you know, the judge usually bases whether or not they're going to let you out, how much bond you're going to have, if they're going to give you a signature bond. That's usually based on the charges, your criminal history, and whatever the district attorney has to say. But not in this case. In this case, she based it on what she read and what she had to say. Interesting. Never saw this before. And we won't see it in those other courtrooms that I bring to you good folk. I may watch more of this judge just to see how she handles cases. Look at people with similar charges, similar histories, especially if she get black folk in front of her. I want to see how she handled those cases. People with similar histories, similar criminal backgrounds, similar allegations, and similar warrants. Yeah, I might be watching more, man. And then maybe, just maybe, I'll have an answer to, is there a difference between black and white justice? So what do you people think? Let me know in the comment section. But that's all. I appreciate you good folk coming through, man. You know, you could have spent your time anywhere. You decided to spend it here with T.P.O.T, and it is appreciated. I don't take you good folk lightly, man. I never have and I never will. You got my word on that. So, with that, I will leave you good folk with 3 words. You know, like I always do. Open your mind. peaceful. X with another.
The darkness continues.
Only from T.P.O.T. Media. Open your minds.